want to welcome attorney Corey Beckles to the Marcia Week Show again. Thank you so much. Mr. Beckles, where have you been? Thank you. All these
Good.
years from the Marcia Week Show. Thank you. It has been so educational. I tell you. Thank you, Mr. Beckles, for your segments. And I'm going to just shut up now and let you take it away.
Good evening, Marcia. Good
Good
evening to
evening.
everyone. Hope you're hearing me clearly.
Yes, I'm hearing you clearly.
Okay, wonderful. All right, so it's always a pleasure to be here and to share the information. I know that our time is limited, so I'm going to go quickly into our discussion. I did say last week, sorry, that I would go into looking at that case that I had told, well, I had mentioned a case called Selby and Smith as it relates to the rights of beneficiaries, as it relates to the common law spouse. And that case, Selby and Smith, it originated or started in the High Court of Barbados. And what happened is that a lady who was living with a gentleman, he was married at the time, but sometime between the marriage and his death, he divorced. So at the date of his death, he was a divorced man. But the, the time period to qualify according to the law as a common law spouse is 5 years. You have to be living as a single man, according to the law, a single man living with a single woman for not less than 5 years. You must be living for 5 years together to qualify as a common law spouse. But as I said before, the situation is that they got together. He was married at the time. Somewhere in between his them getting together and his death, he was divorced. And what happened is that after he died, his parents, he had no children. His parents also were deceased. So the next in line to inherit was his siblings. But of course, the lady that he lived with was claiming that she was a spouse. She was claiming that she was a common law spouse, even though at the time they didn't spend that 5 year period while he was a single man. She's still claiming that she is a common law spouse. And the brother brought a case against her in the High Court of Barbados, claiming that she was not entitled. And what happened is that the High Court judge found that she was indeed a common law spouse, because the High Court judge said in his judgment that as long as the individual is single at the time of their death or immediately preceding their death, the spouse can qualify. You can qualify as a common law spouse as long as, remember, is the lady that's bringing that contention. She's claiming that she's a common law spouse. The issue is that the man was divorced somewhere in between the cohabitation. But because he was single, because he was divorced, immediately preceding his death, the court still qualified her as a common law spouse because he was single. He was a divorced man immediately preceding his death. But there was a contrary opinion or a contrary view, because the law itself, anybody that reads the law, which is the Succession Act, would read for themselves and see, well, it has to be a single man and a single woman, and you have to be cohabiting for 5 years or more. But this circumstance was a bit interesting because they did not cohabit for the 5 years as single individuals.
Right.
But the court still found that as long as you're single immediately prior or immediately or preceding your death, as long as you're single immediately preceding your death, you can qualify under the law concerning common law spouses. And this matter started in the High Court. It went to the Court of Appeal because, of course, that decision was challenged. The Court of Appeal actually reversed the decision of the High Court judge because the Court of Appeal looked at the actual law, the actual act, and they believed that, well, it was their opinion that the law says 5 years. It has to be 5 years. You have to be single. Both individuals have to be single. It has to be a 5-year period. If there is no 5-year period in that circumstance, then you cannot qualify as a common law spouse. So, Marcia, it went all the way to the Caribbean Court of Justice. And the Caribbean Court of Justice reversed the decision of the Barbados Court of Appeal. And the Caribbean Court of Justice agreed with the High Court judge. And they agreed that in these circumstances, as long as he was divorced, immediately preceding his death, he was single. And they came to the decision that you cannot, in this circumstance, prevent this lady from qualifying as a common law spouse. So what really happened is that she, along with the same siblings, inherited, because we now have a spouse and we now have siblings. As the persons who will inherit. But it is a very interesting case because interesting for Barbados and maybe also the Caribbean, because as long as you are a single person, man or woman, single person, immediately preceding your death and you have been cohabiting with another individual, it is almost certain that the other individual or the survivor will qualify as a common law spouse. What is also interesting is that you cannot, if you're separated prior to your death, there will be no qualification. So a separated individual is not single. A divorced individual is single, but if you're separated, you're not considered to be single.
I see.
Right? So everything depends on the particular circumstances. But it's still relevant to our discussion because we are discussing the rights of beneficiaries. So if you are an individual who finds yourself in the same situation as that lady, in the same case that I referred to, then there is a very good chance that you will qualify as a common law spouse. But every case that is brought before the court in Barbados and anywhere in the world is determined based on their own particular and specific circumstances, right? So every circumstance will be different. Every specific situation will be different, right? So I want also to continue the discussion concerning the rights of beneficiaries as relates to some practical issues that arise when you are dealing with the application for letters of administration. Because I find that there are many situations where beneficiaries are not being told what is happening with the estate. Now, the right to information, there is not necessarily any written law that says that beneficiaries must obtain information. But when you are dealing with a person who has died intestate, a person who has died without a will, then usually the spouse would apply. And if you have children, it is the spouse and the children who will inherit the estate. And you may have situations where the spouse has applied. The spouse may be a step parent. And you will find situations where the spouse may not be communicating with the children, or the children are not communicating with the spouse. There is not really a good relationship between the children and the spouse. And in those situations, you will find that the spouse, as the applicant, they will have their own attorney. And the children, as the other beneficiaries, will also go and retain their own attorney. But in my opinion, estate matters are practically family matters. For the most part, they are family matters. And it is very important that even though there may be some level of miscommunication, some level of distrust, sometimes some level of animosity, for the benefit of all persons involved, it is best that the parties come together and sit down and determine what is going to happen, how things will happen, how will information be shared, So even though you have two different attorneys, or sometimes you may have multiple attorneys, depending on how each, called the beneficiaries who are the children, the other beneficiaries may even have their own attorneys. You don't know. Some of these estate matters can get very complicated. But nevertheless, these are still family matters, and it is best that the parties, all of the parties, sit down, discuss the matter, and determine how things are going to operate. Because when you have individuals who are not receiving any information at all, it can delay the application for letters of administration. Because now the beneficiaries have a right to file a document called a caveat. And a caveat is a document that stops the application process. So wherever the application is, the caveat stops that process for 6 months.
Wow.
6 months. And not only that,
Wow.
that caveat could be filed as many times as you so desire.
My
So,
goodness.
yes, so an individual who is not being told what is going on, an individual who believes they're being left out, can go to their attorney, and the attorney will keep filing a caveat every 6 months. And at the end of the day, nobody is going to benefit because nothing is being done with the application. So that's why I say go back to what I said at the beginning. It makes no sense taking the risk of not communicating with the beneficiaries. If you are an applicant in an application for letters of administration, even if you are not communicating with the beneficiaries or with the other beneficiaries directly, if you have an attorney, let your attorney communicate with them. Let your attorney let them know what is happening. In fact, the law prescribes that in cases of letters of administration, you must notify the beneficiaries. So you must send a letter, you must send a notice to the beneficiaries, to all of the beneficiaries, to let them know that you have made an application for letters of administration. Either that you have made an application or you will make an application for letters of administration. So the law itself, the procedure, the legal procedure already is looking at these matters as family matters, as ensuring that all individuals know what is happening. That really is the point. All individuals must know who have a benefit, who have an interest in the estate, should know what is happening. It is not we're in 2026. There's so many cases that are still languishing. Some are languishing in the court system, some are languishing at the probate registry because beneficiaries cannot see eye to eye. And when beneficiaries cannot see eye to eye, you need someone to step in to be able to mediate. So we speak a lot about mediation. Mediation is something that can assist the family, that can assist the beneficiaries in ensuring that this estate is actually settled. And that really is the point. The end result is for the estate to be settled. And settlement means that whoever is entitled to the estate receives what they are entitled to. So when we're talking about settling an estate, we're talking about ensuring that everything that is supposed to go to the particular individual as beneficiary goes to them, that they receive exactly what they are entitled to under the law. Because we're not dealing with a will now, we're dealing with an individual who died intestate. So I say all that to say, Marcia, that beneficiaries concerning applications for letters of administration, I would submit that they are entitled to information. They are entitled to communication, and they are entitled to know what stage, what status, what is the status of the application for letters of administration.
Yes, yes. Somebody has a question here. Do you have to give a reason for filing a caveat? If so, what would be possible reasons?
All right. So you don't necessarily have to state the reason for filing the caveat in the actual document itself. But some of the possible reasons is that you believe that the applicant or the person who has put forward themselves to be the applicant are not entitled to make the application. So it could be a sibling makes the application, and the sibling could be the eldest out of all the siblings. But the law says that all siblings are equally entitled. So we're not looking at who is the eldest. All siblings are equally entitled. And there are situations where one sibling may decide or come to the opinion that their eldest sibling is not the best person to make the application. So that is why they will file the caveat. Or you may file a caveat where you believe that the applicant not just doesn't have the standing, the legal standing. The applicant may not even be a family member. The applicant could be someone such as a common law spouse. There are situations where, because as I said before, you have to be declared to be a common law spouse. And there are situations where that individual who believes they're a common law spouse ends up making the application before they have been declared to be common law spouses. And then the family members or the other beneficiaries may have an issue with that. So they file a caveat. So what happens is that once the caveat is filed, then the applicant or the applicant's attorney would respond to the caveat. To file a document, so the response really is through a document called a warning to the caveator. And that warning really initiates a situation where the caveator now must give a reason. They must show a cause why they have filed their caveat. So the caveat, the document called the caveat, you don't necessarily have to put a reason. But as long as the applicant responds to that caveat, now you are put on notice to provide some reasons. Now the person who filed the caveat is put on notice to let the applicant know why have you filed this caveat. Right? And once you file the warning to the caveat, you have a specific amount of time to respond to that warning. If you don't respond, then it could initiate a court action. So that is now you have to go before a judge, and the judge will determine who is the best individual, who is the better qualified individual to make that application for letters of administration. But suffice it to say, the caveat is a very powerful document.
I could tell.
Yes, but yeah, it can be avoided. You can avoid the situation of a caveat just by communicating with the other beneficiaries.
Right. Somebody's asking if it's 14 days to respond to the caveat. If it's a first 14 days.
Yes, subject to correction. I believe that's the amount of time that you do have. It maybe it's 14, it could be 7 days, but I will get the specific amount of time for the audience.
Yeah. Somebody's asking what happens. They say, how does foreclosure works? I guess in this whole thing about rights to estate, this is where the land do not have an actual owner.
Right. So really and truly, foreclosure, as it relates to, there's two different definitions really in the law concerning foreclosure. Foreclosure, as we know it now, refers to mortgages, a bank foreclosing on property. Now, as it relates to property law, there was a legal process in Barbados called foreclosure proceedings. Now, these foreclosure proceedings is what we call, this is the precursor or the original. We now have a situation where there's something called land title proceedings. So the foreclosure process was what we had before Barbados implemented the land title proceedings. And in land title proceedings, you do not have the legal title to property, but you're going before the court and you're telling the court you are entitled to obtain a written document giving you legal title. That's what land title proceedings in a nutshell is. So a person who has been in adverse possession, living on property for 10 years or more, and nobody has prevented them from doing so. The owner, the true owner of the property, has not prevented them from possessing the property, has not prevented them from treating the property as their own. After 10 years, the law gives them the right to approach the court to obtain title to that property through adverse possession. But the legal process for that individual to obtain title is through the land title proceedings. So foreclosure. So if you see any documents concerning property and concerning the rights to property with foreclosure on it, that is the old version or the old legal proceeding, because the land title proceedings came, I would say, is of recent vintage, but recent is still, it was still around for 10 years already. But foreclosure proceedings is those proceedings that allowed individuals to obtain the same title to property as they would obtain through the land title proceedings. And the only way, or the different ways that you can obtain title, as I said, through adverse possession. There are situations where an individual, you may have land, your family has been occupying the land for several years. Your grandparents occupy the land. You know that your mom, your parents occupy the land, but there are no title deeds for that land whatsoever. What will happen? It is not really adverse possession, but you are going to court and telling the court that my family has occupied this land since I was a young boy, young girl. In fact, my mother told me that she was occupying that property while she was a young girl. And you can trace possession of that property for several years. So now you present that evidence to the court, and you also advertise it in the newspaper, because you must advertise. When you're going through foreclosure proceedings, as it then was, and if you're going through land title proceedings, you must advertise in the newspaper to let persons know who may have an interest in the property that you have made an application to obtain legal title to that specific property. So foreclosure is a very old process, but that has been replaced by the land title proceedings.
Okay, wow. So much to learn and know and understand. Somebody's asking, in the case of many siblings, one of them is creating the problem of not resolving the letters of administration. Is there a solution? I was wondering about that.
Right. So the first step really is to communicate. But in this case, I believe that the communication has broken down. Which has led to this particular situation. So in this case, siblings will normally file a caveat, or the aggrieved siblings would normally file a caveat, and that stops any proceedings whatsoever. Now, if the other sibling, there may be different situations. So I'm going to speak about the situation where one sibling has started the process, but they are not following through. So if one sibling has started the process for letters of administration, but for some reason they're not following through, that is when you can actually file the caveat. If communication has broken down, file a caveat. And now that leads the sibling or the sibling's attorney to respond to the caveat. And that also leads now to the matter going before a judge. And the long and short, really, I'm going to get to the end, Marcia, without speaking, as people say, all the long talk. Really and truly, in such a situation, the matter can only be determined by a court of law. That really is the long and short of the story. But I'm just going through the process. So in these cases, you file the caveat, you have a response to the caveat. If there's no response to the caveat, you file the matter in court. And you're basically asking the court, informing the court that the sibling has not been doing what they're supposed to do. They started this matter 5 years ago, 10 years ago, and they're not completing the matter. And the estate is still languishing. There's property that needs to be taken care of. And because there's no letters of administration, we cannot take care of this property and preserve the property for the beneficiaries. So all of this information you will give to the judge, and then the judge will determine whether or not the sibling who actually started the proceedings is competent enough to finish the proceedings, to finish the application. If the judge determines that they're not competent, then one of the other siblings will be appointed to start the process. But remember, you have to start the process over again. You can't continue the application.
Right.
So as long as you have a new individual making the application, you have to start the process all over again. And all this time is going by. Time has already gone by, and more time is wasted in these proceedings. So
Yes.
that's why I said it is really best for all parties involved to communicate.
To
But in the event
communicate.
that they can't communicate, in the event that communication has broken down, then you have to let the court of law decide who will apply. And the court, in its discretion, can ensure that the application is made and also that the application is completed.
Mm-hmm.
So there are cases where the judge may direct. Let's say the application has already been made and the letters of administration have already been issued. The court
Yes.
can direct the administrator to distribute the property. So
Uh-huh.
there are cases where the application has already been completed, but for some reason, the estate has not been distributed. The assets have not been given
Right.
to the beneficiaries. So once it goes to court, the judge can order the administrator or the
Mm-hmm.
administratrix to distribute or transfer the property from the estate to all the beneficiaries entitled.
Yeah.
Right? But of course, court is a last resort. Everything
Yes.
can be done without court.
Communication,
Yeah, it
family
is best.
matter.
It
A
is
family
best.
matter. Here's a question, and we will have another 5 minutes, guys.
All right.
How long does a probate take before the registry is finished? I guess they meant the process is finished.
All right. Yeah, it can take. There are some individuals who file an application. Now you mentioned probate. So there are basically two applications that will go before the court: either probating a will or making an application for letters of administration, as the case may be. Now, there's some individuals who may file an application and they get it back within 6 months. There's some individuals who may file an application and they get it back within a year's time. There's some individuals who have filed an application and 5 years down the line, for some reason, the application still has not been completed. Because as long as an application has been filed, the registry or the registrar of the Supreme Court is the only person that can approve applications. So the registrar, according to our law, must be satisfied. The registrar of the Supreme Court must be satisfied that everything in that application has been presented to him or her. The registrar, before she can even approve the application for the grant of the letters administration or for the grant of probate, you must satisfy the registrar that all the documentation that is necessary to be filed is filed. And also, the registrar can also ask you specific questions that you must answer. So the attorney will file the application, or there are individuals who will also file their own application. But whether or not the attorney files it, whether or not you file in person, the registrar will ask you specific questions. And the registrar may tell you, well, I see that this property at some point in time was owned by your grandmother, something along those lines. I'm just using it as an example.
Yes.
But whatever you mention in your documentation, the registrar can ask you for a death certificate for your grandparents. You may say that your parents are no longer with you. The registrar can ask you to provide death certificates for your parents. Or the registrar may ask you for death certificates for any siblings that are deceased. The registrar must be satisfied
Right.
before the application is granted. So that's why sometimes it takes a while. It takes a long time. In between answering the questions, in between getting this further information or additional information to satisfy the registrar, time goes by, and sometimes it takes a while before the actual application is actually approved. But every
Yes.
case is different. You may have simple matters, but sometimes there are matters with 10 different beneficiaries or sometimes a deceased had 10 children, or had 5 children, 6 children. You have
Mm-hmm.
to make sure that you notify those children. Sometimes you can't locate. Sometimes you may a child may be a child of the deceased may be alive, but you don't know where they are. But you still have to notify the registrar that you have notified them of the
Yes.
application. So it takes time to find that individual. You have to do a lot of research. It takes a long time. So there's really no set period of time, specific set period of time for the application at the registry to be completed. But some individuals will gauge it as between 6 months and a year. But if it is a complicated matter, it can go much higher than that. Sometimes 5 years, 6 years, 7 years, Marcia. And
Wow.
unfortunately, sometimes more than that.
More than that. Sometimes people die and gone, and it's still they're fighting. They're
Right. It's
still
still,
fighting.
yeah, it's still,
Yeah.
still,
Yeah.
still has not been completed as yet.
Yeah.
And next week, because I know time has run out,
Yes.
next week we can look at what happens when you are near the completion of an application for letters
Yes.
administration, but the applicant has died. What do you do in that situation? How do you move forward from there?
Right.
And we can look at that next week, God willing.
Yes, yes, most definitely. This has been very educational for me. Outside of this, I literally had no clue.
Right.
I didn't understand anything. And I must say, as you see me here, I literally am taking notes each week, and I'm learning each week. And I want to say thank you. Did anybody tell you you're a great teacher?
I heard it before, but thank
You're
you, thank you for that.
Yes, you are doing a great job. I must say, because I'm following you. You follow. You paint a good picture, and I follow along, even though I'm a novice.
Right.
So, I see some questions in the comment section. But what you can do, I promise you, if you message me at 2367000 with those questions, I will send them on to Mr. Beckles. Okay, or you can hold them until next week. All right. Yeah, I
No
agree. This
problem.
lawyer is very knowledgeable. He's very knowledgeable, and we appreciate it, Mr. Beckles. And thank you so much. In fact, I think I might have an invitation for you, but I wonder. I'm going to send something to you. All right, just cross
Yeah,
my mind.
no problem. No
All
problem.
right. Thank you so much, Mr.
Have a good
Beckles.
night. Yes, thank you.